If a cop asks you, "Do you have any weapons in the vehicle?" you are about to find out exactly what to say. This video is specifically about the 5 traffic stop mistakes that turn legal, law-abiding gun owners into criminal defendants. And by the time we are done, you will have the exact words, the exact legal citations, and the exact moves that keep you free. Here is what most gun owners believe. If you are legal, licensed, and cooperative, you are protected. Be polite, be transparent, answer the officer's questions, and everything will work itself out. That is the conventional wisdom. That is what you have probably been told. That belief is costing people their freedom. Transparency is not a legal strategy. It is a gift to the prosecution. Every single question an officer asks you at a traffic stop, questions that feel like small talk, is a legally structured attempt to build probable cause. And the moment you answer, you have handed them the ammunition to charge you. Being legal does not protect you. Knowing the law protects you. Those are two very different things. I have spent years breaking down state and federal firearms law. Not courtroom theory, but street-level real-world application. I analyze actual cases, real arrests, real convictions, and I am going to show you exactly how those arrests happened step by step. Here is what we are covering today. 5 mistakes, 5 legal solutions, starting with the one that will physically protect your life, not just your legal record, all the way through to the final move most gun owners never know they can make, legally ending the stop on your own terms. Stay through all 5. The order matters. Mistake number 1. And this is the one I am starting with, because it happens to almost every legal gun owner, and almost no one sees it coming. Consenting to a vehicle search. Not because you wanted to, but because a trained officer made it feel rude to say no. Here is the scenario. The officer has your license. The stop should be over, but instead of sending you home, the officer leans on your window and says in a completely casual voice, "You don't mind if I take a quick look, right? It'll only take a second." Or, "I'm just gonna check the back seat real fast, okay?" Or the one that gets gun owners every time, "If you've got nothing to hide, you don't mind me looking." At that moment, most people say yes. Not because they have something to hide, because they feel social pressure, because they want to seem cooperative, because saying no feels like an accusation against themselves. But here is what the law actually says. Officers cannot search your vehicle during a routine traffic stop without 3 things: probable cause, a warrant, or your consent. That is it. If you give consent, that consent is valid and binding. Everything found in that search is fair game in court. The charges will stick. What makes this worse is that officers are trained to frame the consent question so that both yes and no can be interpreted as permission. You don't mind, right? Say no, I don't mind. That is a yes. Say, I'd rather you didn't. That is evasion, which becomes the justification for suspicion. There is only one correct response. Look directly at the body camera every officer is wearing and say these exact words: "I do not consent to any searches." Not, "I'd rather not." Those are ambiguous. The phrase, "I do not consent to any searches," is legally unambiguous. The body camera picks it up. No officer can later testify that you gave permission. Say it as many times as you need to. Calm, polite, firm, consistent. The consequences of consenting, even when everything you own is completely legal, are severe. Officers may mishandle your legally owned firearm. They may find items entirely unrelated to firearms that create additional charges. And if anything found sits in a legal gray area, the fact that you voluntarily consented rather than asserting a constitutional right will be used against you in court. Do not consent, ever. That stops the search from starting. But here's the problem. Some gun owners do the right thing at the window, then destroy their case the moment the officer asks a follow-up question. That is mistake number 2. Mistake number 2 is where more legal gun owners end up in handcuffs than almost anywhere else. Not because of what they did, because of what they said. Here's the setup. You have already disclosed your firearm if your state required it. The officer has your license and registration. By every legal measure, the stop should be ending. But the questions keep coming. Where are you coming from tonight? Where are you headed? Has anyone else been in this car today? Is there anything in this car I should know about? These are not small talk. Every one of those questions is a legally structured attempt to get you to provide facts that justify extending the stop or searching the vehicle. Under the 4th Amendment, an officer needs consent or probable cause to search your car. These questions are the machinery they use to manufacture one. Here is what the law says. The 5th Amendment gives you the absolute right to remain silent and not incriminate yourself. That right applies on the side of the road exactly as much as it does in a courtroom. When the officer asks where you are coming from, the correct response is, "I plead the 5th, that is it." Not, "I'd rather not say." Not, "I don't answer questions." Those phrases are legally ambiguous and can be characterized as uncooperative behavior. "I plead the 5th" is constitutionally precise. It cannot be twisted. You might be thinking, I have nothing to hide. I know exactly what is in my car. But here is the brutal reality. You cannot guarantee what is in your vehicle. A passenger may have left something in the seat cushions. Someone may have tossed something through an open window. Courts have seen gun owners charged with possession of contraband they genuinely had no knowledge of. In their own words, "There's nothing in here, go ahead and look," became evidence of deception when something was found. The legal and financial stakes here are catastrophic. A felony weapons conviction can carry 5 to 10 years in federal prison, a permanent lifetime ban on firearm ownership under federal law, and legal defense fees that routinely exceed $25,000 to $50,000, even for cases that are eventually dismissed. Stay silent. Plead the fifth. On every question beyond your legal obligations, every time. You have stopped the search, you have stopped the interrogation. But the third mistake is one that can end your life, not just your legal record. And it happens in a split second when you reach for something in your own car. This is not a legal mistake. This is the mistake that can get you killed. And it happens because gun owners do not know the one iron rule of traffic stops with a firearm present. You never, under any circumstances, touch, handle, or reach toward your firearm in the presence of a law enforcement officer. Here is how it goes wrong. The officer asks you to hand over your registration. It happens to be near your holster or the glove box where your weapon is stored. You reach for it naturally, without thinking. Or the officer says, "I'm going to need to secure that firearm for officer safety. Can you hand it to me?" And you think, "I'm compliant. I'll just cooperate. I'll hand it over." Do not do it. The moment you have a firearm in your hand with a law enforcement officer present, that officer is legally justified under qualified immunity and use of force doctrine to take virtually any action they deem necessary for their safety. And they will not face legal consequences for that action. Here is what the law actually says. Officers can order you out of the vehicle under Pennsylvania v. Mims. They can conduct a limited pat-down under Terry v. Ohio if they have reasonable suspicion you are armed and dangerous. And if they want to secure your firearm, they have the legal authority to do so themselves. They do not need you to hand it to them. The correct response when an officer says they want to secure your weapon: "Officer, I am not going to touch that firearm in your presence. I will tell you exactly where it is, and you are welcome to secure it yourself." Then tell them the location. "It is in the center console. It is in the glove box. It is in a holster on my right hip. Keep your hands up and visible. Narrate every movement. I am keeping my hands on the wheel. I am not making any movements." Let them retrieve it. The consequences of reaching for or handling your firearm range from a lawful use of force response to criminal charges of brandishing, menacing, or assault on a law enforcement officer. Even when your intentions were completely innocent, those charges carry 5 to 15 years in many states. Hands on the wheel. Tell them where it is. Let them get it. You have protected yourself physically and legally, but a lot of gun owners who do everything right still end up sitting on the side of the road for 45 minutes wondering what they can do. Mistake number 4 is not knowing your state's disclosure rules before you ever start driving, and it can create charges before the conversation even gets started. Mistake number 4, and this one happens before the officer even speaks to you. Most gun owners have no idea whether their state requires them to inform an officer they have a firearm, and that ignorance alone can result in criminal charges. Picture this. You are driving home after dinner with your family. Red and blue lights flash behind you. You pull over, you are legal, you are licensed, you feel completely fine. But then the officer asks, "Do you have any weapons in the vehicle?" And you either say nothing when you were legally required to speak, or you volunteer information when you had absolutely no obligation to. Either way, you have just handed the officer a reason to escalate the stop. Here is what the law actually says. There are 3 distinct categories of states, and you must know which one you are in before you ever start the engine with a firearm in your vehicle. Texas is the clearest example. If you have a license to carry, you are legally required to inform the officer you have a firearm as soon as practicable when interacting with law enforcement. Failing to disclose is a criminal violation in itself. That means charges, fines, and potentially the loss of your carry permit. You do not wait for them to ask. You tell them. States like Florida fall here. You are not required to volunteer the information, but if an officer directly asks whether you have a weapon, you may have a legal duty to answer truthfully depending on your permit status. Lying or refusing to answer can expose you to obstruction charges. Indiana is a prime example. The law does not require you to say anything about a firearm. However, and this is absolutely critical, not being required to disclose does not mean that disclosing is harmless. The moment an officer learns a gun is present, everything about that stop changes. The tone shifts. The questions shift. The legal justification for extending the stop shifts. The solution is non-negotiable. Before this video ends, look up your state's specific duty to inform law. Write it down. Know it's cold. And if you travel across state lines with a firearm, which millions of gun owners do, you must know the rules of every single state you pass through. Ignorance of the law is not a defense. Courts have ruled this over and over again. In duty to inform states, failure to disclose can cost you your carry permit permanently. It can result in a Class A or Class B misdemeanor with fines reaching $4,000 or more. And in aggravated circumstances, it escalates to felony territory. One omission, one traffic stop. Your carry rights gone. The problem is, gun laws change, and they change state by state. If you want to make sure you're never caught off guard by a law you didn't know existed, hit subscribe. Every week, I break down exactly these kinds of updates so you know before you drive, not after you're charged. You know what to say, what not to say, and how to handle your firearm. But the final mistake is what lets a routine stop turn into a 45-minute detention, and most gun owners have no idea they can legally end it. Mistake number 5, and this is the one almost nobody talks about. Gun owners who do everything right, disclose properly, plead the fifth, refuse the search, then sit on the side of the road for 30, 40, 45 minutes because they do not know they have the legal right to end that stop and the exact words to do it. Here is the scenario. You have done everything right, but the officer is stalling, running your plates again, calling for backup, saying, "Just give me a few more minutes," telling you a canine unit is on the way. What are your rights? Under Rodriguez v. United States, a 2015 Supreme Court ruling, a traffic stop cannot be extended beyond the time reasonably required to complete the purpose of the stop without independent reasonable suspicion of criminal activity. Once the officer has run your license, checked your registration, and written or declined to write a citation, the stop should be over. Holding you longer is an unlawful detention. Officers know this, so they try to manufacture reasonable suspicion through your behavior, your answers, your nervousness. That is exactly why you have already been pleading the fifth and refusing consent. And now you take the final step. Ask 2 questions, on repeat if necessary. Am I being detained? If yes, what is the legal basis for my detention? If I am not being detained, I am free to go. Thank you, officer. And leave calmly. If the officer says you are being detained, but cannot articulate a specific legal reason, that is an unlawful detention. Anything that comes from it, a search, an arrest, may be thrown out in court. On canines, officers cannot extend a completed traffic stop solely to wait for a drug detection dog without independent, reasonable suspicion. Rodriguez confirmed this, but they will try to manufacture suspicion from your nervousness, your answers, and your movements, which is exactly why you have been silent and still throughout the entire stop. When officers sense they are losing control of the stop, they get louder. They make accusations. They say, "Don't get smart with me." Your response does not change. Calm, polite, firm. "I do not consent to any searches." Like a broken record, the consequence of not knowing when to end the stop is a detention that gives officers time to build a case against you from nothing. Extended stops have led to vehicle searches, arrests, and felony charges against legal gun owners who simply did not know they could and should ask those 2 questions. You have the right to go home. Now you know how to use it. Let us make sure these 5 moves are locked in before you get back behind the wheel. Mistake 1. Consenting to a search. The only words that protect you are, "I do not consent to any searches." No ambiguity, no softening. Say it directly at the body camera. Mistake 2. Answering questions you have no obligation to answer. Plead the fifth every time on every question beyond your legal obligations. Mistake 3. Touching or reaching for your firearm. Hands on the wheel. Tell the officer where it is. Let them retrieve it. You never touch it. Mistake 4. Not knowing your state's duty to inform law. Look it up today. Write it down. Know it before you drive. Mistake 5. Not knowing how to end the stop. Am I being detained? 2 words that can change everything. Any one of these mistakes can cost you your carry permit, your right to own firearms, thousands in legal fees, and your freedom. This is not hypothetical. This is happening to legal gun owners right now. Next video. The 7 places your concealed carry permit means absolutely nothing, and walking into any one of them with a firearm could result in federal charges and a mandatory minimum sentence. You will not believe. You will not want to miss that one.